They're not a staff.
Oh, all the way back there?
When you say?
No, in Spanish I just like that. Years I said that.
Today.
No. I'm still changing.
Let's ask for confirmation.
My brain's
You
still
know there's
thinking
a
Spanish.
thing.
I need more shots.
Did everyone get a copy of the article that I
There's a
handed out?
makeup session? Oh, is it for ahead of time?
Yeah, no, you
Did everyone get a copy of the article?
Yes.
If not, I will pass this out.
Anyone else think one? You're welcome.
Like it's right. It's just gonna end at 5.
Attendance sheet?
Oh, yeah, if you guys could just pass around, sign this attendance sheet, let me know if you're in the morning section or the afternoon section of the class.
Yep, and this isn't shared with Professor Burda, it's just for us to keep tabs on things,
Yeah, just
so,
for us.
you know, it's not like a credit thing.
Right.
I'm trying to say.
Alright, so before I get started, I kind of just want to lighten the room a little bit, because I know what we covered today was kind of a lot, and I understand it might be a little overwhelming. So, to start off, do you guys have any questions for me generally? Anything anyone's wondering? CREAC, structuring, general worries, nothing? Okay. So, my main premise to this is don't worry, take a deep breath. It's a lot, but it'll start to sink in. So, first up is gonna be outlining. Try to resist your initial desire. You're gonna wanna say whether or not, yes or no, is this, you're gonna wanna state your conclusion right away, but resist that urge, because by the time you're done with your outline, you may change your mind. So the outline process is a way for you to organize your thoughts and figure out where the weak points are. Do not cut and paste from authorities, that's really important. Even if you think they've stated something really well, you don't wanna just take it from there. You wanna read through, find out what they're saying, why does it sound so good, why do you wanna put it into your paper, and then kind of translate it, like Caitlin, kind of translate it into your thoughts and how it affects your case and what you think the conclusion should be, not just using this one part of the case as part of your outline. So, large scale and small scale organization. So large scale is meaning the big parts, obviously the CREAC and of your entire paper, all 3 pages, but also small scale within each paragraph. So focus on that. And your strongest arguments, you want to put those up front first, because you're not going to want to start off with your weakest argument. Whoever is reading it is immediately going to be like, well, are you really making a sound argument here if you don't put your strongest arguments up front? And you might not know what your strongest arguments are until you're done outlining. So yet again, another good reason not to conclude right away. And it's also a good way to find out which arguments you actually need to resolve your issue. Like if you have it laid out CREAC and you realize, uh-oh, I'm not really sure what my rule is, it means you just need to go back and read through and figure out what exactly you're trying to say there. Let's see. Where do you start an outline? I normally start, what is the issue? What am I trying to solve? Put that up at the front and just base off of that. And it doesn't have to be, perfectly stated, just your general idea of what you're trying to prove. And as you go along, you can refine that and get it to be more and more precise in exactly what you're trying to say. As far as rule statements, you want broad rules and then narrow down to the nuances of each rule, because one rule might have, 2 or 3 parts that you have to prove, and you want to state it generally and then give the reader each step that they need to get to whatever the rule is trying to prove. You have to explain all the law, explain everything that you're illustrating to prove your case before you apply your facts. In other words, you can't use anything in the application section that you haven't already explained in the explanation section, and I'll go more into that too. And then legal idea topic sentences. It might be a good idea to kind of structure your outline that way, like your main issue, and then list out all your legal idea topic sentences, and then within each section of those, you're going to want to put the different points or whatever that support that legal idea topic sentence. So it's just kind of a skeleton. You can have issue and then legal ideas, and then fill in what you're using to prove those legal ideas. Is any of that unclear? Anyone have any questions about that so far? Nothing? Okay. Let's see. And then for your outline, like Professor Burda said, it's going to probably take longer than you expect. You're going to want the outline to be as close to a a finished product as you can get. That way it's easy to kind of translate it into a paper because it's really already written. So you just take out, you know, the organization, the bullet points, or whatever you use, and then you just convert it into a paper. So it should be as fully developed as you can possibly get it before you really start writing. And that's what the outlining process is to develop your thoughts. So it makes sense that it would be fully developed by the end when you're done. This is just kind of a general overview of the legal writing paradigm. This document is on Twen that Professor Burda made for you guys. It's really thorough. This is a very brief overview of what you need to know. But if you have any questions about that, there's a really good document he put on Twen for that. So our purpose of legal writing is always to evaluate how the court will rule on a legal issue, not whether or not the client is guilty, not whether he'll be convicted, just one specific issue, in your case, the dangerous weapon. And, let's see, discourse criteria, you always want to remember your audience, consider your tone, what's your purpose, and what is the extent or scope of your writing, exactly what issue are you covering, you don't want to be too broad. This is just to give you guys kind of a general overview of what an actual memo would look like. You are, again, just focusing on the discussion section. That's the only part you're doing. You don't need to worry about any of this. It's just kind of a bird's eye view. All right, so the beginning to each CREAC is going to be a conclusion statement, legal idea, topic, sentence. And for each CREAC, you're contemplating a single issue within that CREAC. So a legal idea, topic, sentence, or thesis sentence is stating your conclusion on the client's idea or issue based on basic reasoning. You don't want to be too specific, general principles. And the way I like to think of legal idea, topic, sentences is, why are you using this specific case? Why this one over another one? And it's kind of hard to consider for you guys because you're only allowed to use a statute in the Powell case. But, I mean, the same principle applies. Why are you using Powell? What exactly is it about that case that helps prove your point? And you want to pick out for the legal idea, topic, sentence, whatever the most important, relevant, or significant idea is that that case has set forward, and tell the reader, this is exactly why this case supports my point, in a general way. It can be 1 to 2 sentences. Usually, I find they're usually 1 sentence, but it can go around to 2. Core reasoning, use the rule language, but not verbatim all the time. I mean, some of it, you can't really change the wording, little parts, but you want to be paraphrasing and using the rule language to kind of flavor your ideas rather than just directly copy and pasting. And then key legally significant facts as far as why it is or is not a dangerous weapon, whatever it is you're trying to prove. And then sometimes legal ideas will be expressly stated in a case if you're lucky, but sometimes they're not, and you have to synthesize those ideas based on whatever they're saying in the case. You have to come up with, okay, why do I think this is important? Why do I think this supports me? Because it's not always going to be stated. Sometimes the court is very brief and they don't have a lot of time and they've just, here it is, and then you have to figure out, okay, why did they make this decision? What about these facts supports that conclusion? Okay, so when you get more towards the end of your paper, and I'll talk about this, but sometimes a really good editing tip is to just pull out all of the legal idea topic sentences, put them in order, and read them, only those sentences, and see if they flow together. If they don't, you have some adjusting to do, but that's kind of a good editing technique. Rule statements, pretty simple. Define it. You'll either have a statute, which you guys do here, or a common law derived from cases. And again, use the relevant language from the statute as far as defining dangerous weapon. Again, you want to be general here and move from the general down to the specific. And then also this can be sometimes more than 1 paragraph. I'm not exactly sure what it'd be for you guys. I haven't looked that closely to figure out exactly how much it would be, but sometimes the rules take a lot of explaining to do. Sometimes they're pretty in-depth. I think for you guys, I don't think it would be too bad, but yeah, sometimes you have a lot to explain to the reader before you can really introduce to them other cases and say how this rule applies. So be general, but give the reader enough so that they know the rule going into looking at the cases you're going to explain and why they apply. For the explanation section, you definitely want to begin these paragraphs, there might be more than 1, paragraphs with a legal idea topic sentence. And for this problem you guys are using, it's gonna be an implicit rule about reasonableness. So something that's not expressly stated that you come up with as far as why a reasonable person would be afraid. Again, not always gonna be expressly stated. You might have to synthesize some of these, which might feel kind of weird coming, like, oh, I have to come up with this rule, but that's what we do as lawyers. So you may have to say something that's not expressly stated that you've come up with on your own. So, room to be creative there. And then, like Professor Burda said, this isn't a steadfast rule, but usually for you guys now, you wanna use facts from the case that you're illustrating, the holding, and the reasoning in that order. You can switch that up when you get a little more experienced and really kind of be creative there too, but for now, for our purposes, try to just go on that pattern. And again, the only case you're using here is Powell. Just want to reiterate that. Sometimes you're going to need to have more than one explanation paragraph. You might do, like we say, CREAC, it might be CREAC, or even 3 explanations and then 4 applications. It might be more than one, so don't expect to just explain a case. Even just one case might take 2 paragraphs sometimes if there's significant ideas in there that you need to explain to the reader to figure out why that case supports your position. Okay, so after you've explained a case or illustrated a case, basically proved what that case is trying to say, you have to apply that reasoning to your own facts. So you want to start this up front with a conclusion that does that applies what you just talked about in your explanation section to your facts here. And there's no citations in this section. You've already done that in your explanation in your rules section. You've already done all of that. Here is our facts. You're not going to be citing to our case. You should just be talking about the general principles that you've just proved and applying them to our situation without citing. For this, you're going to use rule-based reasoning based off of the statute or based off of analogical reasoning based off of cases, in this case Powell. You're going to analogize. And Powell was similar to this because this, or this. Or why it's not, but that'll come later. Don't apply or talk about anything, any law, any rule, any case in the application section that you haven't explained and discussed in the explanation section. So you can't really do that to the reader, only putting something in the application section that hasn't been explained to them. They're not going to know really how to apply that. So you want to be careful you have to apply everything, explain everything before you apply it. And you also want to be, in the application sections, you want to be mirroring the language that you used in the legal idea topic sentences of your explanation paragraphs. Use the same language to kind of see, and you'll be able to just plug in your facts. Like, it's the same structure because the same ideas apply to what you're trying to prove in your case. So just try to use that same language. And that's another reason that pulling the legal idea topic sentences out works really well, because you can see what you were trying to prove and then just set it up so it's your facts instead of the legal idea topic sentences where it has the other cases facts. And then you guys, he does want you to do a counter argument section. So you want to explain how facts or law might make your conclusion less likely and figure out what arguments you need to raise, because you're going to have to figure out what the other side's going to say. You have to address those bad facts or other counter arguments. So explain why they might make your conclusion less likely, but then you need to also explain why, using your reasoning, why they don't actually change your overall conclusion. So acknowledge them, but diffuse the argument and say why it doesn't apply. And I think Professor Burda does want this to be one full paragraph for you guys, which I'll go into later, but that should be about a half page. And this can go at the end of your discussion before your conclusion, or like I was saying, you can have CREAA. You can do it A and then a counter argument, and then the next application, and then another counter argument, if that makes sense. Is that clear, kind of, how that would work? Yeah, so 2 different places you can put it. Oh yeah, the counter argument section is also a way to distinguish your case, because sometimes the facts or the reasoning they're using might be so similar that if you don't explain it to the reader, they might think, well, I agree with the other side, I think this is like this other case, so you have to make sure you distinguish and make sure you say exactly why your case is different, if it is different. So, once you've explained, once you've applied all your explanations, you're gonna have to conclude here. This isn't just a way to really reiterate, I mean, it is a reiteration of your arguments, but you don't wanna just restate what you've already stated. And the way, I have to attribute this to him, Professor Ho said this to us, I don't know if he's already told you guys, but it's not just a repetition, you want to dismount. This is your landing. And it's tough because you are restating things that you've already stated, but in kind of a finalizing way. I don't know, remember who you're writing to and just kind of try to tie everything together at the end neatly without simply restating. Okay. So that's CREAC. Any questions at all? Yeah?
I have two.
Yeah, okay.
So, the first one, the rule, I'm kind of confused as to what extent we're supposed to explain it. Because there's an explanation part.
Yep. So, you're saying you're confused about explaining the rule because you also have an explanation section.
Yeah.
So the explanation, sorry, go ahead, you have more?
Oh, sorry. Just because, okay, so in class, we went over the CREAC and I didn't really have the chance to apply it to what we were doing, but the things I did. The rule, not to get too specific, but the rule that we're looking at, the part that we're focusing on is really small. So if we're only going off of a couple words, I'm kind of wondering what to do to make that an actual paragraph.
So it's kind of like the way, you want to be more formal than this obviously, but it's kind of like how Professor Burda said, explain it to your grandmother. What would the average person need to know to understand whatever the rule is completely?
Yeah.
So even though the rule statement, like the rule that you guys are working off of might be really small, you might need a couple of extra statements to really understand what that means. Like when you say, I don't know, I'm trying to think of a good example of a rule, but any rule, like you can't do this. Okay, well, why not? Why can't I do it? Why is it that why is this even a rule? You know what I mean? So even though it's a small statement, you might have other things that the reader might not, because you read all the cases, but the reader, the generally uninformed reader who is probably still a lawyer, might not know all the details that you know. So is that kind of cleared up a little?
Are we allowed to use, we're allowed to use Powell in the rule then, correct?
Yes.
Like almost like the holding of Powell would be a rule?
Right, yeah,
Okay.
exactly, because that case, whatever they're holding, that sets the rule that the other courts have to follow, so you're
Okay.
exactly right.
So the rule will be a combination of the statute and the holding from Powell, basically?
Exactly.
Okay, and then,
Sorry.
I had two.
Go ahead.
I have a question about citing, if that's all right.
Yeah.
When it says, Mass General Laws, Chapter 265, Section 17, it has that little character for section.
Yeah.
Do we have to find that on the computer?
Yep, and
How
the
do
way
we
you
do that?
find that, do you have Word or, you guys will be using Word because you have to upload it onto mine. So for Word, I think it's in, just under symbols or, Max, I don't want to explain it.
Special
backwards, but-
characters.
Yeah,
And it
special
shows up,
characters.
and it's default, there's no assignment, but like if you use Alt-S, that'll bring it up, because Alt-S is an assignment.
Yeah, that's what I was trying to do.
And you can it might be a good idea, because this is, I find that really annoying to have to go in and find that little symbol every time. You can
Yeah.
assign it a shortcut and just,
Cool.
and just type it in there. So, yes, as far as citations though, don't worry too much about them right now. That was a really good question, because yes, you do have to cite the statute.
Yeah.
But, don't get too deep into that now. Professor Burda is really worried more about your writing, and I will go a little more into that, but yeah, you definitely use that little symbol.
Okay.
And, yeah, go ahead.
Sorry, I tried already, no.
Go ahead.
I just want to be clear, you said we're only doing the discussion part for this assignment. So
Right.
is it basically modeled after that CREAC exercise that we just did?
Yes,
Like that would be
exactly.
considered a discussion?
Mhm.
Okay.
The only difference, like a regular memo is gonna have some lead-in stuff to tell the partner or whoever it is what the question is, because sometimes if the partner is so busy, they don't have time to read your discussion section at all. So they might only read your brief answer, and they might just read that, go to a meeting to talk about this, and then later, I'll figure out what the reasoning is later. So don't worry about that for now, because that's not what you guys are doing, but yeah, just the discussion section, don't worry about any of the lead-in stuff, just that. Go ahead, that's okay.
Reading the Powell case, they cite lots of other cases, and we're not using those other cases.
Right.
But I wanted to know to what extent we're allowed to use the court's logic, so the court's pulled upon multiple cases, in order to reach these other ideas that are specific to Powell. If they're using other cases to get to their decision,
Right.
we're not allowed to use any of the words they're coming up with from those cases. We have to like wait until they summarize it in their own words in Powell.
Not necessarily. Normally you would be able to use those other cases, and
Yeah.
you'd in fact have to use them with integrity issues. But for this case, pretend that any reasoning that appears in Powell comes only from Powell. So
Okay.
you can still use it, but again, you don't want to be using it verbatim or copy and pasting. Whatever. If you think that they've used a good line of reasoning,
Yeah.
paraphrase it, and just
And-
cite it to that part just in Powell.
Cite it to Powell.
Right,
So even
right.
if it's like, they have a paragraph and then at the end, they cite it to Tanner or whatever.
Yeah,
team
just
is.
Powell for now. Yep, just Powell. Yeah, no problem. Anything else, anybody? Yeah, go ahead.
So for like the explanation part,
Mhm.
is that more, you're just basically like explaining what happened in the Powell case, right?
Yes,
Okay.
yeah, exactly. I'm gonna go
Okay.
back to that slide so I can really just tell you that. Okay, yes, that's where, so the explanation section, it's kind of strange because these are sort of CREACs within CREACs. That's what we mean by large scale and small scale organization. You're doing technically one big CREAC,
Yeah.
but in the explanation section, it's kind of also like, it's not a full CREAC because, never mind, I'm not even gonna go into that. But yeah, so, cause you're starting your legal idea topic sentence is kind of your conclusion on that case and what the reasoning was. And then you're explaining that idea with a case. So you're saying,
So the
this is what
first-
happened, yeah, go ahead.
So the first sentence of the explanation should be like what you think happened, what the conclusion of the Powell case was, or what the conclusion of what the
Yes,
what you think
yes.
the Dodd case.
In a way, but the specific holding of the case that you're using is not always necessarily gonna be the most important legal idea that you have to use.
Okay.
So an idea might be found in any part of the case.
Okay.
So it's just basically an idea that's most applicable to your case, but that came from this other case.
Okay.
And
So-
because, so remember, you're gonna be applying it to your case later, so, yeah, go ahead.
So do you like wanna try to like concise it down when you're explaining about the case, because like I've kind of like got on, just started the explanation part a little bit, and
Mhm.
I just kind of found myself like going through Powell and doing that.
Like I have to explain the whole thing.
Yeah,
or-
exactly.
Yeah, and that is tough to boil it down, but
Yeah.
the way to kind of combat that is try to make a list of like what are the most important points in Powell and why did they find that way? And it is helpful to have the whole case, obviously, but we don't have room for that. So that's why just the specific facts, like you're not gonna need to know necessarily like, I don't know, what he was
Like-
wearing or, you know what I mean?
How many inches like of the weapon or the?
Right,
okay.
right, you're not gonna need every single
Okay.
fact, it's only the legally significant facts, only something, I'm not gonna go into that either.
Yeah.
Never mind. Sorry,
No,
too many things in my
no,
head right
it's
now,
okay.
but,
No, you know, that was something.
yeah, just boil it down, only what's the most important, and what did the court decide, and why did they decide that? Anybody, anything else before we go into editing policy? Yeah, go ahead.
I just wanna make sure, so he said 3 pages, it's not double-sided, is it? Like, it's just the front of each page?
Yeah,
Okay.
just, no, yeah, cause then it would be 6, yeah, 3 pages, it can be double-sided, yeah.
Gotcha.
Okay, editing. This is my favorite part to do, is edit. Everything that I've put in here is from the document, the article that I gave you guys, so you have all this. This is just my way of digesting it. Get into character when you read your own work. Don't read it as you. Print it out, recess yourself, and then go back to it and be like, hey, I am my boss, or I am a totally uninformed legal reader, or sometimes it might even be the client who really knows nothing about the law or the issues or something. So really get into character, assume the other side's position sometimes too, and that will help you to figure out what your best arguments are, how clear you've been, and figure out what arguments you might need to diffuse. And your end goal here, Professor Burda says, you want to be an authority. You want to assure the reader that you know what you're talking about and that you are a reliable authority. Be seamless in your transition. Don't, be too wordy or unorganized. You want it to flow evenly. And you want your conclusion, whatever you're telling the reader that you think is the outcome, you want to, through your writing, make that outcome inevitable. Use your reasoning to kind of draw the reader there to say, well, after what I've already said, I don't even need to say my conclusion. You already know it's this answer. So also, most importantly, not biting off more than you can chew. This assignment cannot be done in a night. I know I, as an initial law student, was like, challenge accepted, but it doesn't work that way in law school because your brain gets tired. It'll shut down after a certain point, and your writing is gonna be not nearly what it could be. So get it out, look at the document, step away. If you wanna, in between edits, in between writing, whatever it is, and this is applicable to all of law school, whatever you're doing, you're gonna get bogged down in it. Like, this is heavy left brain stuff. It takes a huge toll on us that isn't necessarily as physical. Like, if you're, you know, I don't know, in a manual labor job, like, you can tell you're tired, but your brain gets tired the same way too. So step away, watch a show, eat something, whatever it is, and then go back and start editing, because your brain will be a lot more easily able to pick out what mistakes you're making. Because if you're just reading it over and over again in succession, like, my eyes start to glaze over, I start seeing the same thing. And to the next point, that's where you want to print it out, put it in another form, like a PDF. It just helps to other the document kind of, and read it out loud to yourself, which is really effective because things sound a lot different when you're reading them out loud than when you're reading them in your head. Let me see. What else am I trying to say? Okay. Hunt your document. Don't be sentimental if you're writing. It will not help you. If you don't want to cut out a passage just because, oh, but it sounds so great, it's so excellently crafted, and you know, we might think our first draft is, oh, this was just so great, but if your argument is off or unclear or whatever it is, you might have to cut out an entire paragraph. So, and that hurts because I know sometimes we're trying to really reach those page limits and it's like, oh, an entire paragraph, but that is the reality of what you might have to do sometimes. So don't get married to any kind of an argument, be flexible, be willing to change it up. And then, if you find that something doesn't sound right, don't just get rid of it. Figure out why doesn't it sound right, and pretend that you're the editor of a paper. Pretend somebody else has written this, you're editing it. Justify whatever you want to take out. If you've determined this doesn't sound good, I mean, you couldn't really do that as an editor to someone else, just take it out. You'll have to hand that to them and say, you need to fix this. Why do you need to fix it? If you can articulate that, you'll be able to fix whatever the sentence is. And then the most important thing while you're going through this, editing is tough, and it can take kind of an emotional toll on us too. It makes us question our abilities as writers. Don't do that. You guys are very smart. I can already tell I've only met you guys a few times, but you are all here for a reason. Like, you're all already very good writers. And just remember that, keep that in mind, no matter what, you know, what you might think along the way, because I'm very, very hard on myself, and especially in this class, it can get tough. So just remember that when you're writing, you're already a good writer. So all you're doing is improving from here. Okay, this is kind of the small scale editing within individual sentences. You want to be informal. You don't want to use legalese words like heretofore or, you know, whatever. I don't know. People tend to think they need to use those words because we're doing legal writing, and you don't. You remember who you're writing to. You're writing to the uninformed reader, or sometimes your boss. Your boss doesn't want to read a bunch of, you know, whence, this, whatever, heretofore, whatever. They don't really want to read that. And also this throat clearing language. It's tough because a lot of that is kind of our instinct. Like, we think we need to say that, like, based on the fact that or whatever, but that's not really what we're looking to do here. You want to cut those words out, be as concise and succinct as possible. Avoid the passive voice, which says, like, Carly went to the store, or no, that's wrong. I'm sorry, I'm really bad with coming up with examples on the spot, but passive voice is like, right now, I'm really bad at this, but like
Car
saying,
that was blue, something.
yeah, the car that is blue, the blue car, that's active. You don't, right, thank you, blanking here. And then avoid nominalizations. Saying assumptions or statements or actions, you want to cut that down to act, assume, or state. And then when you're describing your cases or the other cases, you always use the past tense. because it's important within every sentence. You might not notice that you're doing it, but that's another editing tip. Sometimes you might wanna go through the document just for tense, only looking at what tense you're using, make sure it's past tense. Don't excessively quote. If I'll go into attribution later, but quotation is different than attribution. Just because you're using an idea that came from a case doesn't mean you need to quote it exactly as it is. You wanna paraphrase and attribute at the end with a citation. And then obviously avoid I, we, our, you, or your. You might eventually be required to write like that if you're in a firm, you know, it'll be regular, the partners will just say our case. But for now, we're being like the most professional we can be in this, so you don't wanna say any I, you, or your. No contractions at all. And what else? Oh yeah, structure. Be short and simple. Use subject, verb, object. This person did something to whatever it is. Be as simple as you can, which will feel kind of weird because in undergrad we're kind of taught to get away from that, and you want your writing to be, you know, academic. But this is less like that. So it'll feel weird, but just be more simple with your writing. Okay, this is kind of a little checklist for you guys. To figure out the flow, pick out 2 paragraphs at a time. It can be any paragraphs, right in the middle of the document, your conclusion and then your rule and explanation. You can even separate them, like your end conclusion and your beginning conclusion and your end conclusion. And are you using transitions? Does everything flow from one to the next? Does the first sentence of your explanation paragraph make sense with the end of your rule statement that you've just written? It might even be a good idea to just pull out those 2 sentences, your ending and your beginning sentences, and just read those together. Unity, you don't want to be bouncing around between ideas and confuse the reader. Just explain one idea, one paragraph, then move on to the next idea. And again, you want a legal idea topic sentence for every paragraph that you're writing. Cohesiveness, present it in a logical order. Again, that's definitely something you want to do. Paragraphs, you don't want the paragraphs to go for the entire page. Nobody likes to read that. It's very unpleasing to the eye. You want to break it up and make sure the paragraphs are no longer than like a half or 3/4 of a page. Any questions about editing?
So,
Yeah.
in the explanation part, like if you have like, obviously it's gonna probably be almost 2 paragraphs, right? Because, or
Yeah.
close, probably, or at least one big one.
Like you might have more than one.
Yeah,
Yeah.
exactly. So I'm saying when you break it up, would you, so usually you open with a topic sentence or whatever, and then for the next one, would you open with another topic sentence and then like continue?
Exactly,
Okay.
exactly, because each paragraph is a different idea.
Okay.
So whatever idea you've done in that paragraph, and if you think that it's too long, that means you're not being concise enough. If you
Okay.
feel like, oh, I'm explaining this one idea, but it's like 10 sentences, you need to cut down your ideas themselves.
Okay.
Okay. Anything else? Before I move on to attribution. So attribution, this is citation, but it's also a little different. You guys are only using the statute in the Powell case. So as we were discussing before, just pretend any idea that comes from Powell is only from Powell. Anytime you're using the court's reasoning, paraphrasing of their reasoning, an idea supported by their reasoning, whatever you are asserting, even if you've come up with it on your own, even if you've synthesized it, you got that idea from somewhere. You did not come up with it on your own normally. You had to read this case to figure out that idea. So you have to attribute it to the source that gave you that idea or that concept. Where does this go? This goes in the rules section and the explanation section. Nothing in your openers, nothing in your application sections, nothing in there should be cited. As far as how often to cite, look at that, the Tinker, the sample document that Professor Burda gave you guys in class today. It might feel like a lot. It might feel like at the end of every sentence, seriously, I have to cite something, but yes, it might be that often. Only in those sections, not every single sentence, but it will feel like more than you think you need, but every time you're reiterating an idea that comes from a case that's supported by case law, you have to cite it. Let's see. Why? you have to attribute. Mainly, one of the considerations is stare decisis, like, do we have to follow what we've done before? And you're showing where your ideas came from. Yeah, basically just every single time you're making a legal assertion that supports, or anything that supports a legal assertion or has a basis in an authority, one of the cases for the statute, you have to attribute that. And again, this doesn't necessarily mean that you're quoting. It doesn't mean like every time you have an idea, you have to quote something, specifically not trying to do that. And if he sees too many quotations, he told me before, he might even say no quotations at all. So I would find that extremely difficult, but you want it as much as you can, and that's not to say you can never quote, because you can. Sometimes the court has just said it so perfectly, you just have to quote it. But most of the time, you want to be thinking about these things, digesting them, and then putting them into your own words, because, you know, whoever you're writing this for, if you're just quoting, they could just go on and read the case. You know, why not if you're just quoting? So it has to be something synthesized that's coming from your own thoughts. And then, okay, we're gonna do some hypotheticals, unless anyone has any questions. Anything at all? Nothing? Okay. These are just integrity hypos. I don't know if you guys might have already looked at these, but Professor Burda really wanted me to go over them just to make sure. So I'm just gonna read them and you guys tell me what you think. Does it implicate, can you guys see that? Is that big enough? Yeah, all right. Tell me what you think. Does it or does it not violate the policies? On the first research assignment, you and a friend decide to conduct the research on laptops next to each other. Your friend finds a helpful secondary source and tells you the source. Does that violate anything?
I mean, I think it does, because like the class is for research, and you're not supposed to help somebody get to the answer quicker than they would do on their own.
Exactly. Yeah, this is a big one, because I mean, it's inevitable you guys are at some point probably gonna be studying together, but definitely don't do this. I know the instinct will be very strong to do this, but definitely avoid it at all costs. All right, I won't go through all of these, but let's see. I feel like number 4 is fairly obvious, but number 3, you received the class notes of someone from last year's legal skills class, which happens to contain all of his writing assignments and in-class quizzes.
It's good to go.
That's fine. And you know, they know this happens, so that's why you guys are learning is different than regular, so you can't even really do this. It won't help you even if you got this, but yes, this is definitely a violation. Let me see. How about number 5? While surfing the internet in connection with a research memo, research for a memo you're writing, you come upon a writing sample of a law school graduate whose writing sample is substantially similar to the memo you're writing. While you don't intend to import any of the person's text, you hope to gain inspiration with respect to the analysis. Is that okay? You say no? Why not?
I don't want to take a chance. It's not worth it.
That is a great call. Great call. Err on the side of caution. If you find yourself questioning it and like trying to find a loophole and saying, you know, is this okay? I wonder. The answer is probably no. And all of these implicate grounds for referral to the association, which is not a fun process to go through. So avoid it at all costs. Don't do it. All right. That's really all I have for you guys. Yeah. Go ahead.
I thought all of them were pretty obvious except for number 2.
Okay, let's see. Classmate life skills emails you to ask whether you would mind if he or she finds the documents you accidentally included your closed memo draft, which has not yet been reviewed by Professor Burda and your rating. So this implicates the collaboration part. Even though it's by accident, it's still technically getting transmitted to them. So that's why we just have to be extra careful about setting something, because this applies in the real world. If you have something that's confidential of a client's and you accidentally email it out to the other side or something, that's you could get fired for that. So it's a good idea to just start now being extra careful about what you're sending to them.
Like you,
Yeah.
I mean, obviously, like most people accidents, if you make like a mistake or something like that, email
email
back
back
and
to
be
like,
like,
who's
oh no,
this
like,
or?
yeah, we're, I mean,
Exactly.
not like that
Yeah.
all the time.
Yeah, I mean,
But-
definitely make efforts to try to fix the situation, but
Is that something you're supposed to, like an honor contact thing, or are you supposed to be like, let somebody know? I don't know, 'cause, like, I feel like a lot of that is, you don't know, like, nobody knows until they find out.
exactly, and you really don't know the answer to that. I always assume, because I'm paranoid,
Yeah.
that the school is like watching the email server.
I,
So, I don't know,
already.
you never know, but, it's probably not happening, but you never know. Maybe they'll say like, they saw these, they're collaborating, and that's on the school server, so technically they do have access to it, so I don't really know, is the answer that unfortunately I have to give you. I would consult Professor Burda on that as to exactly what are the right steps to do if an honest accident does happen.
I see.
Anything else? Any of you guys wondering about anything? Editing, writing, whatever? If you are freaking out over the weekend, I'm just gonna be at my desk working, so if you guys need to email me within reasonable hours, feel free to email me, midnight at, on Sunday is probably not the best time, but anytime Friday, anytime Saturday, anytime